Your Honor, if for a minute it were to be accepted that people who are pursuing a political cause within the meaning of Article 38 of the Constitution will be tried in Kahawa, we shall not only make a mockery of our national security, we shall also end up weaponizing the law made for terrorists to deploy it against those that we think we disagree with politically. And that is where the issue of political persecution comes in. And Your Honor, we urge the court not to go back that road of weaponization of the judiciary against sections of the Kenyan citizens with opinions that inconveniences the government of the day. We've been there before. It was a catastrophic time, and the reason why the 2010 Constitution exists. Your Honor, that point I make it with regard to two last issues that I'm about to make. Sections 42A of the CPC, Sections 42A of the Criminal Procedure Code, these sections, Your Honor, says it talks about the disclosure by the prosecution. 42A1 says, pursuant to Article 52J of the Constitution, the prosecution shall inform the accused person in advance of the evidence that the prosecution intends to rely on and ensure that the accused person has reasonable access to that evidence. 2 is the one that is most important. In the proceedings under the Prevention of Terrorism Act, the Narcotic Drugs and Psychotropic Substances Act, the Prevention of Organized Crimes Act, the Proceeds of Crime and Anti-Money Laundering, and Counter-Trafficking in Persons Act, the prosecution may, with leave of the court, not disclose certain evidence on which it intends to rely until immediately before the hearing. Then the other provision sets out. You know, why is this section important? This section is important for the simple reason that because terrorists are such dangerous people, that we've read, it's a CPC, sections 36A. CPC, section 36A. Just sorry, 42A, sorry. We were dealing with 36A, the other side. 42A. Your Honor, what is it about this section? Your Honor, what this section is based on is because those specified offenses are deemed to be of such a severity and so harmful to the public and to national security that despite Article 50 of the Constitution, the state is allowed to prosecute the case without availing all the evidence at the commencement of the trial. That is an absolutely important issue because one of the most important safeguards, you get the materials for your trial. So when you try a terrorist, you use a lower threshold. You can keep some of the evidence, you can suppress, which is not possible with the crimes that they were initially charged with. So that, Your Honor, the point that we are therefore making with regard to sections 42A is that if you agree that people pursuing a political cause will be charged under provisions of the law and before a court under which they will enjoy less protection, it would be a very, very dangerous thing to be done. The final point, Your Honor, is on the famous Githunguri versus Republic case. I believe this is a case, 1986, we all know it. I am a fan of listening to interviews by JSC. when people are being invited to be for higher offices, majority of judges cite this case as one of their favorite decisions. And I believe it is for a good reason. And what's the main point of Githunguri that I want to urge today? It was about abuse of power, abuse of court process. But more importantly, there is an important phrase that was made in the language of the famous Justice C.B. Madani, to the effect, Your Honor, that a good prosecution or a lawful prosecution is determined at the commencement on how it starts, not how it ends. We have submitted this has started as terribly, as unlawfully as it is possible. I have heard from the prosecution when it was responding later on that, oh, we shall sanitize this. We shall give evidence. Everybody will be satisfied. Let them wait. Your Honor, in the case of Githunguri, the point was what is unconstitutional in a demonstrable manner cannot be sanitized, cannot be constitutionalized. I urge the court, and I thank it for giving us time to ventilate that issue, to dismiss this, and to discharge specifically the accused person until they are lawfully presented before this court. Your Honor, we are most obliged. Thank you.
I wish to add 2 points to what my learned colleague has said. Constitutional question. Excuse me. Yeah? Your Honor, I wanted to address these issues together with my learned raised. The doctrinal application. It is implied in Article 160 clause 1, where this court is presumed to be independent and impartial. And Your Lordship, you derive your powers from the people of Kenya under Article 159.1 of the Constitution. So I want you to read Article 159.2e. It obligates you to apply for any demonstrator, then you can now assign that indicated, Your Honor. And that is why they are all bound by Article 1 and Clause 2. The Constitution they violate Article 24 and the other